Every day in the USA, people find themselves in court.
All right, our next matter is entitled The Estate of Pleadings. Ruth Marie Fraser Snyder. And the defendant is Catherine Marcial, who is present. Also is Karen Vanderwall, who I think has an interest in this. Keely Beamer is here on behalf of the plaintiff. And James Shinar from Kalamazoo filed an appearance that I got just this morning with his perspective on things. There's also a jury demand. Good morning, everyone.
Morning, Your Honor.
I did go through the advice of rights, Ms. Beamer, with the parties in the last case, so we can get right to this one. I got Mr. Shinar's appearance, I guess, yesterday. It was filed. You probably got it also, and he filed an answer. So I'll start with you, Ms. Beamer. What's our status here?
Correct, Your Honor. The status is the same as when the complaint was filed. Ms. Marcial remains on the premises. We have an ongoing estate administration. Unfortunately, it's in a liquid estate with some claims and at this point, actually a pending foreclosure on November 2nd. So, the personal representative is just attempting to get this property vacant so that we can proceed with sale to proceed with the necessary administration.
Mr. Shinar, what's your client's position?
Your Honor, this matter has been pending for a long time. The parties have, at least through counsel, attempted, I think, in the best interest of everybody to talk, and talking has not worked. My client moved back here to take care of mother. She's been in the home and she's put a lot of money into that process. As referenced, the claim is now pending. At least it went out in yesterday's mail in the probate court. She's stuck at this point. She's got no place to go. And at this time, she's one of three siblings that I understand would be the beneficiaries of this estate. And two of the three, I understand, don't want this action to be here. I think it's a shame that we have to be in a courtroom at all in this process, as opposed to just talking and working through the issues. But it's a probate matter as opposed to a real estate matter. I understand that the premise behind the request for her to leave at this point is based on a realtor saying, I want a vacant house when I put it on the market. I get the foreclosure aspect. The mortgage has not been paid in the last couple of months or several months, but at this point, there's more value in a house if they could sell it than the foreclosure action. So I would hope that that could be worked out as well. So my suggestion and recommendation is put it off on an eviction process, let the probate court work it out, or get these parties to talk because they just don't.
All right, well, let's unpack this a little bit. Ms. Vanderwall and Ms. Marcial are sisters.
Yes.
Is that correct?
That is correct, Your Honor, as well as the personal representative, Mary Smith. They're all three sisters.
And Mary Smith is in there logged in as one of your website, one of yours under Keely Beamer.
Correct.
You're Mary Smith.
Yes,
All right, and you're the personal representative of this estate.
yes.
Well, Ms. Beamer points out one fundamental problem, and you also, no one's paying the mortgage, and it's more than a few months. It probably takes a year or more to start the whole mortgage foreclosure process. So they're living there, no one's paying the estate. You're right, it needs to be sold rather than foreclosed on. But maybe now that you're in the case, perhaps you and Ms. Beamer can talk. She's quite reasonable. the probate court does have preeminent jurisdiction. I haven't discussed this with Judge Tomlinson. The probate court can take over the landlord-tenant case. I guess it could be petitioned to have the probate court handle the whole matter. But they have superseding jurisdiction in a case like this, if they wish to have it exercised. And at this point, I don't think he's just going to ex parte take this case. But obviously, the first thing we need to do is continue the matter. Normally it would be for 7 days. Ms. Beamer, do you want just the 7-day adjournment, or would you like some additional time for you and Mr. Shinar to discuss this? There's also a jury demand in here, which would further complicate the scheduling of it.
Your Honor, I would request the 7-day. With all due respect, Attorney Shinar and I have been in communication. The issue is there's been ample time for an attempt to try to refinance, provide financing to the estate, to be able to provide some liquidity, to be able to move forward. And the continued response is there are no resources available in which to do that. And so in my opinion, and we can talk all we want, but we're not going to pull resources out of thin air. And even with the claims that's been presented to this estate, we don't have the liquidity to pay the claims, to provide the resources to allow for the refinancing. So unfortunately, I think we would ask for the 7-day. And in addition to that, I have had prior cases in front of Judge Tomlinson where it is my understanding his preference is to handle the possession interest here with you and then proceed with all other matters in the probate court once that order for possession is available.
Well, as I said, he's probably not anxious to take this over, but he does have the right if somebody asks him to. All right, so we also have a jury demand. They haven't paid the fee yet, but the check's in the mail, I'm told. And
It is.
The demand has been made. So I could set this for a jury trial in November if needed. Heaven forbid. But as you all, well, ladies, the law requires that I adjourn this matter for 7 days, whether I like it or anybody else likes it, to give parties time to get legal advice and perhaps emergency financial assistance. This is not the type of case that any agency is going to provide emergency financial assistance. It's not a rental agreement. The situation is, the whole cold hard truth is the property needs to be sold and the assets split between the 3 beneficiaries. It doesn't appear that there's a white knight coming in with enough money to pay this substantial arrearage. Now, once the mortgage foreclosure action starts, which she says is early November, there would be 180 days to redeem the property before the foreclosure exists. But right now, I suspect no house payment has been made in probably more than a year. When did Ruth Schneider pass?
She passed away March 24th of 2022, Your Honor.
Has any mortgage payment been made since then?
Not to my knowledge. I don't know if Ms. Marcial can answer that, or Attorney Shinar.
Sir, I can answer that. Yes, I paid the mortgage for 2 years prior to my mom's death, and then I paid it up until January of 2023, which I have documentation in the probate court to show that. When Mary took over as the personal representative, that was when I was no longer able to or did make any further mortgage payments. My financial situation changed dramatically after my mom's death, and I just didn't have the ability to pay that on my own. And frankly, I am not legally responsible, I don't think, to pay that on my own from my own assets. But I did what I could up until January of this year when Mary took over as the PR.
All right, that's probably more than Mr. Shiner wanted you to disclose, but thank you for the background information. All right, we're gonna continue this till next Friday morning, October 20th at 10:30. And then we'll set the matter for a trial. I dread the thought of doing this as a jury trial. But there is an absolute right from the defendant to have one. You're both well represented. According to Ms. Beamer, negotiations have taken place and reached the end of the road. So as a practical matter, that's probably what needs to be done. The question is when. And we will discuss this further next Friday morning by Zoom once again at 10:30 a.m. Does anyone have any questions?
Nothing, Your Honor. Thank you.
Nothing for me, Your Honor. Thank you.
All right, thank you. All right, we'll take another look at it. I haven't had an ample chance to read Mr. Shiner's answer. Anyway, we'll see where we go. All right, next Friday, 10:30. Thank you very much. all
Thank
of
you. Enjoy the weekend.
Thank you.
Okay.
Thank you.
We're returning to the matter of the estate of Ruth Marie Fraser Schneider through the personal representative Mary Smith versus Catherine Marcial and perhaps others. Keely Beamer is here on behalf of the plaintiff, and James Shinar is here on behalf of the defendant. We made quite a record on last Friday, October 13th. Since that date, I've received a jury demand and payment for same and an exhibit and an answer. So I'll defer to you first, Ms. Beamer. We learned that this is in a foreclosure. This is a family circumstance. Plaintiff wishes to get the property vacated and sell it before it's foreclosed. And defendant has different view of things. What's your perspective, Ms. Beamer?
Yes, Your Honor. Good morning. Similar situation than where we were last Friday. Unfortunately, Attorney Shiner and I did have some discussions on, possible, we'll call them negotiations, but unfortunately, it's been the theme of the communication on this property that there just aren't resources. There weren't resources to move when originally asked. There aren't resources to pay the necessary expenses to maintain the property. And so the fact that some offers of, there's a certain amount of money that's going to save this from foreclosure, I haven't been able to verify or receive any communication back from the foreclosing firm that bringing the note current is going to stall this foreclosure. All representations that we have in communication is basically they're at the point that it's paid in full or foreclosure will commence. So unfortunately, with some of the communications that we've had, I don't know, while they're options, I don't know that they're actually a viable solution. And I think that our position remains the same here this morning.
Who is the foreclosing entity?
Right Path Servicing is who has the mortgage. Potestivo and Associates is who we've received communication from. And I've attempted to respond and correspond with Jessica Oliveri, who is the appointed counsel for the matter. I've left 3 messages now on varying dates and times and received no communication back.
What's the name of the managing company again?
The servicing company, Your Honor,
Yes.
is Right Path Servicing.
Who was the original lender? Miss Marcel, you seem to know who that was. Who was it?
Yes, sir. Originally, the mortgage was with Chase and then it was sold to Right Path.
All right. Mr. Shinar, I do appreciate the fact the two of you have spoken in the last week, but it seems like if we have a mile to go, we've gone about 2 feet. What's the current status from your perspective?
Well, I don't know what's been disclosed to the court as to what my proposal was yesterday. And I understand, and Ms. Beamer we have not spoken, but we've emailed. So let me put it that way. How I understand, and my client, from my understanding, has had some limited communication with the servicing group or whoever that would be, determined that there's an outstanding balance owed of somewhere in the ballpark of $9,000. And her being my client and her other sister are trying to pool money. And they made a request yesterday that if each of these three individuals can pool a third each, that they can come up with that $9,000 first to keep out of foreclosure or get it out of foreclosure. Because the last email from Ms. Beamer to me, which was Tuesday the 17th, said that unless full payoff is provided prior to the second, the foreclosure sale will take place. If they've got the 9,000 or can get the 9,000, hopefully, number one, we can keep it out of foreclosure. So that was first thought yesterday in my email that I haven't heard a response to. Second thought with that is if we can stop the foreclosure and get the balance paid up, my client has said that she would continue making payments to keep the house out of hock at this point in time, while we try to figure out if she can actually buy the house. And if not, then the house goes up for sale. And we can discuss what's necessary to have that happen. But I have requested that this eviction process stop, and let's make that determination before somebody gets booted out, especially if the premise is, number one, foreclosure, if we can stop it. And number two, the house has got to get sold, and we haven't discussed, can we sell it with the person in the house? So that's why I've jumped in on this, Judge. I think it's something that I would hope we can resolve. And if we can't resolve, instead of kicking one of the three supposed owners of the house out, when two of the three say, I don't feel that that's the right course, I think there's other ways we can handle this peacefully. And we're doing our best, Judge. We don't have access directly to the companies, and there's been communication back and forth. I don't know the exact balance, but my client has told me it's in the ballpark that I told you. I think it's doable. I know that, what's the other sister's name? I'm sorry. The one that was here. She actually is taking money out and paying taxes to have this happen. So it's a strong effort on behalf of two of the three to stay in a house and or keep it out of foreclosure, and let's make the best we can on the estate side of things.
What's the other sister's name? I wrote it down, but
It's Karen Vanderwall.
That's right. And I've seen the checks, Your Honor, so I know it's in the processing from her accounts. She's made requests. I've seen where the taxes have been taken out, and the effort's being made to keep this house afloat in this estate.
well, I don't know if this is a matter of rearranging deck chairs on the Titanic. The personal representative may not wish to do that. One party wishes to sell it and sever it and split the proceeds. So they've brought this action to do just that with the people that are in there. They've allowed it to get near foreclosure, which Ms. Beamer refers to as a lack of resources. And now they're scrambling. So there's a lot of hurdles to get over. First, they have to overcome the foreclosure. Of course, even if the foreclosure starts, it takes 180 days to get to the finish line at minimum. So that would be an ongoing process. In the meantime, I don't know if this house needs repair, foundation, roof, windows, that sort of thing, or what the status of it is. You've demanded a jury trial, and many of the things that you're just listing that you're trying to do are not defenses. They are issues that you wish to accomplish in an effort to protect the interest of your clients. But they probably would not be admissible in the issue of whether they can terminate the tenancy. I'd set this for jury trial for next Wednesday, but we've got all kinds of things that need to be done to get prepared for that. Plus, they're going to be tearing this building all up. Judge Stutzman has a jury trial next Wednesday that's probably going to have to be adjourned because they're going to be making lots of noise. Ms. Beamer, does your client have any interest in what Mr. Shinar is proposing?
That's a difficult question, Your Honor. As far as contributing money towards the property in an event to try to capture whatever equity may or may not be available to be saved, no, she doesn't have a lot of inclination to do that at this point in time. Unfortunately, you know, the decedent did pass away in March of 2022, and there's been no action during the original portion of this administration where Attorney Shinar's client held out as the trustee. There was no action being taken to, you know, refinance or to get this into a different type of financial position. It's only when we file the notice to quit that we're now scrambling to come up with resources. You know, Attorney Shinar's client on the record is as late as last week indicated that her financial situation was of such that she couldn't afford to make those payments or weren't available. And so it's difficult when my client is faced with the proposal that she'll continue to live there and make the payments necessary to keep this thing out of foreclosure. In the event, and I'm not sure that that's even an option, the amount of money paid would stall the foreclosure. That's hurdle number one. Hurdle number two for my client is then on the demand that we remove this from the docket and payment within a month or 2 months when resources are no longer available, it returns back to delinquency. We're left with starting over with an eviction process in order to be able to sell and liquidate on behalf of the probate administration. One of the main issues that we have with the listing agent that my client has spoken with is the struggles of potentially listing and showing the house. Now, there are some improvements that could take place. It's my understanding that Ms. Marcial has several dogs in the house, which are going to interfere with the ability to show. Her schedule and availability would also be one that would be difficult in trying to get this listed and sold. So unfortunately, you know, this avenue is not the choice where my client would like to see it. But unfortunately, the writing's on the wall, and this is the option in the event that we can get it pulled back from foreclosure. But we're not in a position this morning, Your Honor, to agree to withdraw the eviction if we want to set a jury trial out for a while and continue to negotiate and see if the funds come in and foreclosure happens. But aside from that, I mean, we're on the same path as we were last Friday, Your Honor.
All right. Now, is this property in Tamarack?
Yes, sir.
Yes.
It's listed as Mackinac Road. I don't think that's correct. Is it Mackinac Drive?
It's just Mackinac. There is no road or drive.
Okay. And I don't have a sense of how, has the house been appraised? Do we know what a potential, how much equity there is in the house?
Yes, Your Honor, the house was appraised.
You don't have to tell me the amount, but
Okay. I mean, there's a decent amount of equity in the house with the current listed payoff. So there is, I mean, it's worth something to try to keep it out of foreclosure, but the problem is we're running up against a deadline, and I don't know what representations are being made to Attorney Steinhar's client, but we have gotten no responses as the authorized individual on the account. So I struggle to understand what information may be being released to Attorney Steinhar's client at this point to come up with that number of 9,000 with the assurances that that's going to stall the foreclosure. Again, this is information being presented, but I'm having difficulty verifying that.
Let me just verify. Good morning. Are you Karen Vanderwall?
I don't believe
I
she's
believe-
joining.
Well, I've got somebody in the bottom. I thought it perhaps was her, but maybe it's another litigant. It may be, I don't know who it is. All right. Well, we've got this boulder in the stream of a jury demand, which is why it's there, because it is a boulder in the stream, and I'm not going to get bullied by it. I'm going to try to set this for jury trial as soon as I could fit it in. But just by the nature of things, you just got his answer this week. There is the jury demand, the fee's been paid. And as a practical matter, I probably can't do it until sometime in January. I have criminal cases that have filled the jury days. November has deer season in it, so Judge Patterson's unavailable for much of the month. December's got Christmas in it, and we've already filled some of those dates. So I'm going to set this for a pretrial conference. I don't know the date right now, before jury. Those are usually on Thursdays, and I'll find a spot within the next month to put that. And then we'll sit down, talk about jury instructions, motion in limine, other things that may be relevant for a jury. In the meantime, that may give an opportunity for people to get some of these other questions answered. The most fundamental question is, will bringing the property current even forestall the foreclosure? Nobody knows the answer to that. And if that's the situation, we are rearranging deck chairs on the Titanic because they're going to get foreclosed anyway. There are issues about property taxes, property maintenance. Just bringing the property current may not be sufficient. I'm sure I've seen this house, but I don't know exactly which one it is. But we'll set a further pretrial on a Thursday afternoon. Mr. Scheinauer, anything further?
No, Your Honor, and I, as an officer of this court, I will do everything I possibly can to resolve this matter short of court time, and I'm trying to do that.
And I appreciate that. This
And-
is the kind of case that needs competent counsel on each side, which we've got. But you've also got a complicated and difficult set of facts where the cold, hard truth may be property needs to be sold. I'm reading a book right now called Saving the Family Cottage. It's a famous book in Michigan about this very type of situation where siblings own a property and there isn't consensus on what to do with it. There are several of these, but this was the one that my son gave me, and I'm reading it right now. And there often isn't a clear answer other than selling the property and splitting the assets. All right, Ms. Beamer, anything else to add?
Nothing, Your Honor. Thank you.
All right, I will clear that date. I'll probably block out an hour and we'll discuss this on a Thursday afternoon to prepare for trial. But for all considered, don't expect that jury trial will be until after the first of the year if we're able to not resolve the case. All right, thank you all.
Thank
I'll
you.
see you on a Thursday.
Keely, can you call me at some point?
I sure can. I'll try to get you a call here maybe before noon, Jim.
Perfect. Appreciate it. Thank you. Thank you, Judge.
No
Have a good
problem. Thank
weekend.
you.
Mr. Herman, can you hear me?
Yes, sir, I can.
All right, we're having a court hearing and thousands of people are watching you eat. So you might want to conduct yourself as though you're actually in a court proceeding.